Welcome to the Block and Tackle Show, hosted by Karl Block. Karl is a partner in the law firm of Loeb here in Los Angeles, California. He will be tackling some of the biggest issues in business today. Listen, learn, and enjoy as he leaves no stone unturned during deep conversations with some of today's most amazing business leaders. Welcome to the show.
All right, well, look, why don't we talk a little bit about what the theories of liability are and, what the defenses are and how that plays out. And again, to the listeners and viewers, Frank's not giving legal advice. He's just generally speaking about what he's seeing and what people are doing.
Yeah, so like I said, most of the litigation we've seen thus far is litigation by creators, authors, visual artists, playwrights, and the like against the developers of these major platforms and major AI tools. Probably the most high-profile, lawsuit was filed in December of last year by the New York Times against OpenAI and Microsoft. And in that lawsuit in particular, you have New York Times claiming that ChatGPT was trained on millions of copyrighted New York Times articles, right? And there's been other similar lawsuits as well filed by authors like Sarah Silverman, Junot Diaz. A host of other authors and visual artists, as I mentioned. But most of these cases are at a relatively, nascent stage. We haven't seen, most of these cases are still at the pleading stage where the parties are sorting out, okay, we've got some claims that are still in the pleading, some claims have been dismissed. Maybe we need to replead some of the claims. But it's going to take some time for these cases to work their way through the courts. But to your question about the theories of infringement and theories of liability, there's really three main theories of copyright infringement here that have been asserted as against these platforms. The first really surrounds the training of these platforms using pre-existing copyrighted materials, right? So that's sort of one bucket into which I'll place the sort of the copyright infringement theories, right? That the use of copyrighted works to train, something like ChatGPT, that constitutes infringement because you've got to reproduce those works to create a library that the tool trains itself on, right? That's sort of one theory. There's another theory, which is that the AI tool itself constitutes a derivative work, meaning it's been derived from these pre-existing copyrighted works, and so therefore it infringes the works on that basis. It constitutes a derivative work to which the copyright owners have certain rights. It's a bit of a novel theory. And the third sort of major theory of copyright infringement is that these tools are facilitating infringing outputs, and so the output from these tools, that they're substantially similar to the pre-existing copyrighted works, right? So if I say ChatGPT, summarize Karl Block's novel for me, and it spits out a summary or spits out it's some version of your book that is substantially similar to your book. Well, the theory is that the platform and the tool is facilitating the creation of an infringing work. Those are broadly speaking the theories of infringement that are working their way through the courts right now.
Okay, and by the way, just to be clear, the derivative work theory is novel in this context, but in other contexts in copyright, it's well settled, isn't it? That
Sure. I mean, look, the classic sort of derivative work is a sequel, sequel to the movie, or a movie adaptation, a film adaptation of a book. Those are subsequent works that are derived from an original work. So those are classic examples where of course you have to license the original work from the copyright owner. You can't make your own version of the Godfather. You've got to license that original work. So but when we think about it applied in this context, that ChatGPT as an AI tool is a derivative work of these millions of works that have been used to train it and that have been fed into the tool. It does seem novel in that context.
Understood, and that makes sense. And then I suppose when we talk about it, and this is probably esoteric for a lot of people, You know, if there is tort liability, and I don't know if this is true in copyright, there's a causation issue about how foreseeable it would be to use a tool to do something. I don't know if in copyright that ever matters, but it's interesting to me for all the reasons that we've talked about uh, the the capacity for inadvertent usage is much higher than in.
Yeah, well, look, I mean, certainly at the level of the AI tools and the developers of these tools, there's really nothing inadvertent about it, right? And the developers readily concede, look, we've used these copyrighted works to train our models. There's really no dispute surrounding that.
Mhm.
The question is whether that constitutes infringement, right? And I think what's becoming clear now as these cases are working their way through the system is that what might be critical is the extent to which the doctrine of fair use justifies the use of these copyrighted materials, right? So some of your listeners might not be familiar with that doctrine, but the fair use doctrine is basically a copyright doctrine. It's enshrined in the Copyright Act, and it allows individuals, entities to use pre-existing copyrighted works in certain cases, right? So the classic case of fair use is if you're using a copyrighted work for criticism or comment or teaching, right? So if you're quoting from a book in the New York Times Book Review, you're not infringing the book because it's part of a commentary, right? Or
Sure.
if I'm going to reproduce or display some famous work of art as part of an art history class I'm teaching, it's because I'm teaching about that work. I'm describing its artistic qualities and such to my students. Those are sort of classic instances of fair use, right? But there are several factors that courts use to determine whether the use of the copyrighted work constitutes fair use. And there tends to be there's four factors, but courts really tend to emphasize two factors as being most important to this question. First is the character and purpose of the use. And what that means is, are you transforming the original copyrighted work in some fashion? Are you transforming it into something new? The greater the degree of transformation, the greater the likelihood that the use will be fair, that it will be fair use. And the other really important factor is whether that use is usurping the market for the original, right? So that factor is typically referred to as the impact on the potential market for the original work. Are you creating something that is going to be a market substitute for the original work? Or are you using something for free in a way in which you would typically license the original work, right? So those are the factors there are others, but those are the primary factors that courts tend to look to when considering whether the use of a copyrighted work is fair use.
Understood, and that makes a lot of sense. And when I was talking about the inadvertence, I was talking about the people who licensed the tool from the AI generator who didn't know. It's a situation where you don't know what they used to create the tool, and so then if you're brought to the party, I think in litigation, if there's an infringement, that they may not just go after the tool creator. And obviously those are litigation strategies that are going to vary case by case, and maybe it depends on the size of the tool developer or the size of the licensee and those sorts of things. But yes, I mean, it makes perfect sense that if you've created the tool, then you are understanding what you're putting into it. It's I won't say little guy, because there could be very big businesses who license the tool and don't.
Yeah, and what I referenced the EU AI Act earlier, right? This is the major AI legislation that
Sure.
was rolled out recently in the EU. One of the requirements in that statute is that, and the requirements differ depending on sort of the size of the company developing the tool, how much of risk that tool poses to sort of the public good and the like. But there are certain requirements for developers to publicly disclose the data on which their tools have been trained, right? And so if we see similar requirements in any legislation that might be rolled out in the future in the US, you might have these platforms that have to disclose what copyrighted works they've used to train their tools. And by the way, by virtue of this legislation in the EU, some of these huge companies that are developing tools that are used internationally might already be under that obligation, right? So if they have to disclose publicly, these are the works that we've used, this is the data we've used to train our tools, then you might see an even greater proliferation of litigation where creators know for a fact that their work has been used to train these tools. And so depending on how this recent legislation shakes out in terms of whether the use of training materials constitutes infringement, we could really see litigation explode in the future.
No, and that makes sense. But and the other side of this, and you know this from litigation, and I know seeing this in deals, supposing that the developer of the tool has to publish the data. The New York Times, okay? That's only been around 3 weeks, right? New York Times hasn't been around very long. Imagine if you're the licensee of the AI tool and somehow this has been the data that they've used has been published per this EU law. And you, as the creator, maybe your in-house counsel, or you've got somebody who has to go through this massive amount of data to see if you're relying on something. I don't know if people are always going to get it 100% spot on. And so it's great that you're making people doing it, but at some level, if the amount of data that went in that you're publishing is put out there, it could be very, very hard not to cross the line, don't you think?
Sure. I mean, look, I don't envy those that need to go back and determine what's been used to train these tools. I mean,
I guess this is just me talking. It would be great if there was legislation that actually allowed you to put a box around the damages that the ultimate licensee had for doing an inadvertent, infringement, because they're not the master of the tool; they're just the licensee of the tool.
Yeah,
but
unfortunately, there's no intent requirement in the Copyright Act. It's a strict liability cause of action. So you've either infringed or you haven't. And if the work you're creating is substantially similar to a pre-existing work, then you're likely subject to liability.
Understood. Now, I think you might have mentioned to me that there's a platform case coming to trial, maybe before the end of the summer.
Yeah. So it's really the first one of these platform liability cases that is scheduled for any sort of trial, and it's a trial that's scheduled in August of this year. It's a case involving Westlaw and Thomson Reuters, which owns Westlaw, and I'm sure the lawyers watching or listening to the program will know what Westlaw is, but some of the other folks watching or listening might not know. But Westlaw is basically an online legal database where you can find judicial opinions, thousands, maybe tens or hundreds of thousands of judicial opinions that have been issued over the years. There's other materials on Westlaw as well, statutes, legal articles, similar sorts of scholarship, but it's predominantly judicial opinions. And the case involves Thomson Reuters and Ross Intelligence, which is a company that sought to create basically an AI version of Westlaw, or an AI powered replacement for Westlaw, where instead of searching the database for legal opinions, running searches to find the particular opinion you need to cite in your brief that you're going to submit to the court, instead you can enter a query into the AI tool and it'll generate an answer for you. You might ask it about a certain point of law, or you might ask it what the status is on a particular legal issue in a particular jurisdiction. Presumably, it can give you an answer to that without you having to find the particular opinion you need to answer that question. Anyway, the case concerns whether the use of Westlaw's head notes, which are these sort of summaries of points of law that Westlaw attorneys have created, whether the use of those head notes to create this AI tool constitutes infringement, right? So, so we may have a jury opine on this issue as soon as August of this year.
Understood. And Westlaw is the plaintiff in this action?
Yeah. Thomson Reuters that owns Westlaw is the plaintiff. Ross Intelligence is the defendant. There were motions for summary judgment filed earlier this year. That's basically a procedure in which you can go to the court and you can say, Judge, based upon all the discovery we've taken, we think you can decide the case, based upon the documentary record, that we don't even need to go to the trial. We don't even need to go to trial. But the judge in that case says, look, there are certain factual disputes regarding the extent to which these head notes were used to develop this AI tool, the extent to which the use of the head notes constitutes fair use or not. And these are questions that a jury is going to have to sort through.
Very, very interesting. Very interesting. And where is it being tried?
This one is in, I want to say it's in Delaware federal court.
Okay.
Yeah.
Keep me posted. Very curious to know.
Maybe we can do another episode after that.
Yeah, I'm going to hit you up about a blog post, but we'll see. But that's amazing. Okay, so maybe we should talk about rights of publicity too, which is something that you have a lot of views on. You know, I mean, it's newsworthy. People know about the Scarlett Johansson OpenAI thing, or they may know a little bit about it, but talk about that and images and similarity in voices and such. What's happening with that?
Yeah, sure. So I think the latest way this cropped up in the news, as you made a reference to a moment ago, is that OpenAI recently rolled out a voice-assisted AI tool, which many thought sounded suspiciously like Scarlett Johansson. Scarlett Johansson famously was in the 2013 film Her, where she voiced a sort of voice assist, voice-enabled AI tool that Joaquin Phoenix's character fell in love with. But it came out that Sam Altman, who heads up OpenAI, actually reached out to Scarlett Johansson twice to see if they could use her voice for this AI tool, and she said no. And they went ahead and used a version that many thought sounded a lot like her voice. I think OpenAI has taken the position that they hired a voice actor to train the voice on, and it's had nothing to do with Scarlett Johansson. Of course, as those who have read about this interesting situation will know, Sam Altman actually tweeted a couple of days before the tool was rolled out the word "her," simply tweeted the word "her," which, if anything, is likely an indication that he was trying to sort of drum up attention for this tool. And I think one can well, perhaps not assume, but there's a good chance that it might have been a reference to Johansson, notwithstanding the fact that she hadn't given permission to use her voice. So anyway, it raises a whole host of interesting legal questions, I think, right? Because look, typically you can't use someone's voice without, in a commercial context at least, without paying that person. And there's also several cases that have been decided years back, including in the 80s and 90s, where there were voice actors hired to mimic famous people's voices, and that was still determined to be a violation of the right of publicity of the celebrity whose voice was imitated, right? So there's a case involving Bette Midler from, I believe, the late 80s, where I believe it was Ford had released a TV commercial for the Mercury Sable, and wanted to and had licensed a musical composition for a Bette Midler song to play during the commercial, but Midler didn't want to use her voice for the commercial, so they hired a voice actress to sort of mimic her voice during the commercial, and she sued and she was successful. There's another case, I think, in the early 90s involving Tom Waits, a very similar situation where Frito-Lay used a sort of a replica of his voice, mimicked his voice for a Doritos commercial. He sued and was successful in that case as well. So we've seen cases like this in the past, but this is and there's no litigation pending in the Scarlett Johansson case, but this is really the first major instance in which we've seen the use of a celebrity's voice, or a celebrity's voice being mimicked in the context of AI. And being used in the commercial context, right? So yeah, it's a fascinating case, and we'll see if there's litigation that stems from this.
It is, and I'm going to actually pose a hypothetical to you, okay? And when I had Anatoly on, he talked about elections and what was going on overseas, and people created voices, and I think there was one in New Hampshire that we can talk about in a sec. But let me just ask you this. Former presidents, when they're no longer in office, often go out and their voice is used for commercial purposes. They do speaking functions. They get paid for it, things like that. If in a political context, somebody created Barack Obama's voice, and used it as part of a campaign. And let's say it wasn't Barack Obama, he didn't authorize it. Is that also a copyright issue because somebody is using it to exploit? And maybe if it's a PAC or something like that. I mean, when does the copyright versus non-copyright overlay work in situations like that?
Yeah, it's a good question. So I mean, so these are not strictly speaking copyright issues, right? Because
Sure.
there's no, it's not. These aren't creative works we're talking about. It's not a. You can't copyright your own voice, but it arguably implicates the right of publicity, which is so
Sure.
for those who aren't familiar with it, the right of publicity is basically the right that we all have essentially to protect the commercial use of our name, image, likeness.
Yes.
And now it seems voice as well, right?
Okay.
So that's one claim that could be implicated here. Another, there are other potential claims under the Federal Lanham Act, which is the federal statute that governs trademark infringement claims, also unfair competition and false advertising claims, right? So you could have a false advertising claim or an unfair competition claim on the basis that the use of this material, the commercial use of this material, poses a likelihood of consumer confusion, right? That's another potential claim that could be implicated here. But you've got to balance these claims against First Amendment concerns, right? So if there is a use of one's voice in a way that is justifiable under the First Amendment, if it's being used, for example, for satirical purposes or parodic purposes, or for news reporting purposes or documentary purposes, those types of uses typically are permitted, notwithstanding the fact that there might otherwise be a cause of action for a violation of one's right of publicity or other types of legal claims, right? But so those are sort of the countervailing interests. But in the type of case that the type of sort of hypothetical that you pose, where you've got sort of a politician's voice being imitated in a way to sort of influence voters or influence elections, I mean, putting aside the fact that it's usually concerning from the standpoint of maintaining our democracy.
Sure.
The question of whether it gives rise to a legal claim, I think, is an unsettled one. And it might come down to whether it's being used in a commercial context, because typically, in order to claim a violation of one's right of publicity, your name, image, likeness, or voice has to be used in a commercial manner, in a way that is, is generating income for the user, right? So maybe that's where this type of case would be decided, right? So if you're using it to drive voters in one direction or the other, query whether that's a commercial use. It might not be. If you're using it to raise money, and to raise money not as maybe there's some sort of argument that it's being done in the profit in the context of a nonprofit. That doesn't seem compelling to me. But if you're using it to profit, if you're using it to put money into your own pocket, then it seems like that's a lot closer to a violation of the right of publicity. It's interesting because it reminds me of another case, not a legal case, but sort of a situation that arose about a year ago or so, involving what's commonly referred to as fake Drake, right? So there was an anonymous producer that created a fake Drake song, and this producer it was an original composition. The producer created the music, had authored the lyrics for the song, but he had used an AI tool and trained it on Drake songs to generate a voice that sounded very, very much like Drake. And he used that AI tool to record vocals for this song that he had authored, right? It wasn't clear that he had ever generated any income in connection with that song. So it sort of fell on the borderline. It wasn't clearly a right of publicity violation. But that's, I think, the first time that certainly people in the entertainment industry piped up, and that the public piped up and thought, hey, we might have something really problematic on our hands with how AI can mimic and replicate real voices, and the potential confusion and damage it could cause.
I mean, I get it. And was there a suit?
No, there wasn't a lawsuit. I think the song was available briefly on streaming platforms, and it was on TikTok, I believe, and it was taken down once there was sufficient press that was generated. But no, there was never any litigation that materialized. Now that instance, that sort of fake Drake song, has been cited as the inspiration for some recent legislation, some legislation that's been passed at the state level and some legislation that's been proposed at the federal level in an effort not only to extend the right of publicity clearly to protect one's voice as part of one's likeness, but also to make it unlawful to use AI tools in order to mimic one's voice. So we're seeing legislation now that has already passed in some states and that has been proposed at the federal level to try to prohibit that sort of conduct.
I think this area it's obviously complex. It's obviously new. This is something that you do, but even so, it's so vast, and there's going to be more and more improvements. And it's like you said, lawsuits follow from conduct, and so does legislation. And I could see how this is going to be such an iterative process, where even legislation that's promulgated now might not be good enough a year or two or three from now. And I guess especially when we find out that AI can just make movies, and how much litigation there's going to be about that. But look,
yeah, I'm sure the unions will have something to say about that.
I'm sure they will. But listen, this has been an amazing discussion. I do think I'm going to probably hit you up for a little bit of some blog updates, but this is really good. I think the viewers and the listeners are really going to enjoy this. A lot of this stuff, I don't think that was top of mind for them, and maybe it will be more top of mind for them, which is really good. So you did a great service today. And for all of our viewers and listeners, if you have any questions about this podcast, you can reach me at Karl, Karl, at blockandtackleshow.com. And the and is not an ampersand, it's AND. So Karl at blockandtackleshow.com. If there are questions for me, I'll try to get back to you. If there are questions for Frank, I'll forward them to Frank, and we'll go from there. But Frank, thanks very much for coming today.
Thanks for having me, Karl. Happy to be here.
Thanks for tuning in. If you want more info on the show, please visit blockandtackleshow.com. And you can also email me at Karl at blockandtackleshow.com. Thanks for tuning in.